Another Ed Talk, better than a TED Talk, and another update in the Donna Adelson case. This time, the update concerns her efforts to have the Appellate Court, the First District Court of Appeal, rule that Judge Everett should have granted Donna Adelson's amended motion to disqualify him from the case. Hi, I'm Ed, not AI, and as you may recall, we've been providing you coverage about this issue here on the channel. And now, we are ready to announce the result of the petition. It was a huge win for the Florida Attorney General's office and the prosecution. Judge Robert Long wrote the opinion of the court denying the petition for writ of prohibition and also denying the requests to treat the filings in the appellate court confidential. The opinion is great and self-explanatory, so I'm going to go ahead and read it to you. Title, First District Court of Appeals, State of Florida, number 1D 2025-0949. Donna S. Adelson, Petitioner v. State of Florida, Respondent. Petition for writ of prohibition. Original jurisdiction, Stephen S. Everett, Judge. Dated May 9, 2025. Signed, Judge Long. Donna Adelson seeks a writ of prohibition to prevent the trial judge from presiding over her criminal trial. Adelson argues the trial judge should have recused himself based on her amended motion to disqualify. She claims that the trial judge engaged in improper ex parte communications with the state by reviewing search and seizure warrant applications. The warrant applications involved Adelson's husband's phone records and a wiretap of his cell phone. Adelson claims that because the warrants relate in part to her and her criminal prosecution, the judge's review of these warrant applications constituted ex parte communications and has given her a reasonable fear that she will not receive a fair and impartial trial. These claims are meritless and facially insufficient. We deny the petition and right to explain why. It is routine for trial judges to review warrant applications and then preside over the resulting criminal trials. Trial judges also commonly issue arrest and search warrants for criminal defendants that have pending cases before them. Adelson's petition amounts to an attack on this common practice. We begin with the general prohibition on ex parte communications. See Florida Code of Judicial Conduct, Canon 3, paren B, paren 7. Quoting, the Code of Judicial Conduct prevents judges from initiating or considering ex parte communications concerning a pending proceeding, unquote. See Reichman v. State. But there are times when a judge must engage in ex parte communications. The Code of Conduct contemplates this and permits a judge to, quote, initiate or consider any ex parte communications when expressly authorized by law to do so, unquote. Florida Code of Judicial Conduct, Canon 3, paren B, paren 7, paren E. The review of arrest and search warrant applications is a core function of the courts. Article 1, Section 12 of the Florida Constitution addresses searches and seizures. It requires a judicial determination of probable cause before a warrant can be issued. Article 1, Subsection 12, Florida Constitution. It also provides, quote, this right shall be construed in conformity with the Fourth Amendment of the United States Constitution as interpreted by the United States Supreme Court. And the Supreme Court has explained, quoting, the pre-search proceeding is necessary ex parte, since the subject of the search cannot be tipped off to the application for a warrant lest he destroy or remove evidence, unquote. Franks v. Delaware. That is to say, ex parte judicial review of warrant applications is constitutionally authorized. Judicial review of warrant applications is also authorized by Florida statute. Quoting, A search warrant authorized by law may be issued by any judge, including the committing judge of the trial court having jurisdiction where the place, vehicle, or thing to be searched may be, unquote. And with respect to wiretapping in particular, quoting, upon such application, the judge may enter an ex parte order as requested or as modified, authorizing or approving interception of wire, oral, or electronic communications, unquote. In short, the ex parte communications in this case were expressly authorized by law. They are, therefore, not subject to the general prohibition on ex parte communications. Because Adelson does not allege any ex parte communication beyond the ordinary authorized review of warrant applications, the petition is facially insufficient. Adelson also moves this court to determine the confidentiality of records filed in this court, including the petition and appendix. Adelson, however, fails to demonstrate that anything in the records satisfies a condition that would establish confidentiality under Florida Rule of General Practice and Judicial Administration 2.420(c)(9). Thus, her motions to determine confidentiality are also denied. Rowe and Wilbury, J.J. concur. Not final until disposition of any timely and authorized motion under Florida Rules of Appellate Procedure or Section 9.331. Signed, Rachel E. Reese of Rachel Reese, PA, Tampa, and Joshua D. Zellman of Zellman Law, Tallahassee, Jackie Fulford of the Law Office of Jackie Fulford, Tallahassee, for petitioner. Copy, James Uthmeyer, Attorney General, and Robert Charles Lee, Assistant Attorney General, Tallahassee, for respondent. Well, that was a big win for prosecutors and for the cause of justice for Dan Markel. I'm Ed, not AI, Deep Dive, True Crime.
Read to you by the one and only Ed from our Ed Talk Show. And remember, Ed is not AI, although he may sound like it. Thank you for making it to the end of this video. Again, I'm Maya with Deep Dive True Crime and Mentor Lawyer Justice Network. Hi everyone, my name is Maya with Deep Dive True Crime, and I'm back with more updates involving the criminal cases that spawned from the murder of FSU law professor Dan Markel, a murder that happened back in July of 2014. In this video, we will give you a few observations about the 84-page initial brief. In this video, we will give you a few observations about the 84-page initial brief that was finally filed in Charles Adelson's appeal by his appellate lawyers, Michael Ufferman and Laurel Niles. Also, and incredibly our own Ed from the Ed Talk Show will read for all of us the entire brief. We will have his reading here too, but first, let me assure you, Ed is not AI. I can assure you of that. He's a real guy. I've seen him, and I'll give you my word. He's not AI, and neither am I. All right, now let's get into the brief.